Hey, everybody, welcome to episode 3 of Legal Muscle, starring Rick Collins, Esquire. Rick has been a contributor to Muscular Development magazine for over 20 years with his column Busted Legal Q&A, author of the best-selling book Legal Muscle, senior partner in the firm Collins, Gann, McCloskey, and Barnes. Did I say it right? Barry. I can't read my own handwriting. Their website is, you can find it, steroidlaw.com, steroidlaw.com for those moments, which all of us hope never happen, but they do happen. He is also the president of the Nassau County Bar Association. Very, very well respected in his community. Please welcome from New York, Rick Collins. Hey, Rick.
Hey, everybody. Thanks, Ron. Good to be back. This is our third foray, our third episode as the Legal Muscle podcast.
Yeah, and you chose this topic, and it's a really good topic because we're talking about the constitutional rights of steroid buyers, and it's particularly relevant because in this day and age, the vast majority of people are not buying their steroids from some trusted guy at their gym or anything like that. It's usually anonymous sources online, even on social media, so they're ordering through the mail, and there are a whole host of other legal issues that pop up when you're buying things through the mail, especially if you're getting them from another country or if it's crossing state lines. So, first of all, what have you seen have become the major changes as far as law enforcement and how they deal with this situation?
So, well, to take just a quick step back, so I'm going to give you my perspective. I've been doing this a long time, as you know.
Yeah.
So, and I've seen the equation from both sides, right? I was a prosecutor, so my job was the other side of the aisle in the courtroom. But I've been doing criminal defense work for many years, and when I wrote Legal Muscle, which was almost 20 years ago, there was still a lot of gym-based purchases, in-person purchases.
Yeah.
As the internet has really taken off. I mean, we get everything online now, right? I mean, Amazon's blown up, so you don't even make a trip down to the local, hardware store, or the local, drugstore. So virtually everything is online. And since 9/11, there's been a higher scrutiny of packages that come in the mail, right? So what I'd like to do today is kind of talk a little bit about the Constitution, which everybody's talking about, right? Usually it's in the Second Amendment now is what a lot of the debate is, and even First Amendment issues and freedom of speech. So you got the First Amendment, the Second Amendment, the Third Amendment. You know what the Third Amendment says, or
no idea?
Good.
I only know the first two.
Correct. So nobody does. It has to do with quartering soldiers in your house, But the fourth, the fifth, and the sixth are important. And I'm going to talk to, this isn't a law class, and certainly it's not legal advice. I say every week, this isn't legal advice. It doesn't create an attorney-client relationship between, just by watching this. But it is legal information. And the fourth, fifth, and sixth amendments are particularly important to anybody who is involved in the gear game and getting anything through the mail that's been purchased by over social media, So just by way of a quick background, and we've talked about this before, right? Anabolic steroids, Schedule III drugs under federal law. Yep. What does that mean? It means that if you have a valid prescription for a medical reason, a legitimate medical reason, then that's from the doctor, that's fine. If you're getting them through the black market without a prescription, without a valid medical reason, then it's a crime. And under federal law, the mere possession of an anabolic steroid, any amount, one, 5 milligram tablet is a crime under federal law. And in some states, that's actually a felony, just the possession of any amount of an anabolic steroid. And importing a steroid, and we're going to get, that becomes relevant because, a lot of what we get in life now comes from Asia, including anabolic steroids. Importing steroids, importing a Schedule III drug is a felony. So, so we've got these laws that apply that at the outset we say, if there is any legal advice to be given, it's don't do it, right? Because no lawyer's going to tell you, go ahead and commit a crime.
Right.
But what I'm assuming now is that people want to understand and know if they were to do this, what would happen, right?
Right.
And when we talk about federal crimes, there's a whole bunch of alphabet agencies that get involved in policing the black market for controlled substances. Obviously, the big one is the DEA, right? The DEA, Drug Enforcement Administration, is primarily tasked with the supervision of drug transactions, of controlled substance transactions, including steroids that might come from overseas or might even come domestically, or any kind of drug transaction. But you also have Homeland Security, what used to be Customs, right? Now they're involved because if you have something coming from China in a package, well, then that brings them into jurisdiction. And the fact that it's in a package itself brings the US Postal Service involved. I've seen the FBI get involved in these cases. I've seen the IRS involved. So you've got, every federal agency has some potential involvement in a steroid case, but it's primarily Postal Service, Homeland Security, and of course the DEA.
Yeah.
So let's take a scenario, right? Petey Pump wants to get jacked, right? So Petey Pump decides, and he's located somewhere in the United States. And so what is he going to do? He doesn't know anybody at the gym, or doesn't trust anybody at the gym.
Right.
And so what he's going to do is he's going to go online, few clicks of his keyboard and mouse, and he finds somebody, maybe on social media. Let's say it's somebody on Facebook or somebody on Instagram or any social media platform, because there are people who are marketing anabolic steroids over social media. And he makes some connections, and before you know it, PD places an order. Maybe he pays cash domestically somewhere in an envelope. Maybe he does it through Bitcoin or a cryptocurrency transaction, which is becoming bigger and bigger. When you ask, what do I see now? I see a lot more of that. And so PD Pump gets his money is given to the dealer that he's met online. And now the package is going to come from, let's say, China, right?
Yeah.
So it comes into the United States. But let's say, lo and behold, Homeland Security, the folks at the airports that scan packages, they're suspicious of this package. Maybe they've got some information about the source, the origin, what's on the package. Maybe they throw it through a scanner. They see a bunch of vials. Let's say, theoretically, even if PD is looking to actually manufacture and sell it himself, maybe it's a raw powder. So now the government says, whoa, let's hold up, let's check this out. So the government starts checking out that package. So now PD gets concerned because, hey, he was expecting his package on Tuesday, and here it is Thursday. So PD now goes on to track the package, right, to see what's going on. But of course, PD's tracking of the package is itself tracked, right? So now PD's IP address is now checking out, whoa, what's going on with that package? So now PD's getting very concerned. What happens? What's going on with that package? And just so we are clear, packages in the mail have protections, particularly if they're domestic packages. So if one person mails a package to another, can feds or police or any law enforcement just open that package to see what's in it? No. You need a warrant to open a domestic package. So when we talk about the Fourth Amendment is about privacy in your person and your home and your papers and your effects. So it's the right to privacy. That's really what the Fourth Amendment is in the context of what we're talking about. So if this was a domestic package, they'd have to get a warrant to open it. But because it's from China, because PD Pump's package is coming from overseas, they don't need a warrant to open it. So they can open that package with a lower level of information. It's almost like a border search when you're coming across the border or you're flying in an international airport. they don't need a warrant to, they don't even need probable cause to subject you to a search. So, so there is this lower level of the expectation of privacy when you come in a situation with a international package. So PD's not protected. The Fourth Amendment doesn't protect PD's package from the feds opening it up. And if the feds find something in there that they then test and they determine is a controlled substance, they basically got three options of what to do with PD. So the first option is basically what we call a seizure notice or a seizure letter. What does that mean? It means if the feds don't like what PD's doing, but they're really not going to go out of their way, maybe the quantity is small, maybe there's a lot more going on in the jurisdiction that those agents are involved with, maybe it's a small order, and so they decide that they're going to simply send a letter to PD saying, look, we found this stuff in a package coming from China. We think it's contraband. We think this is a controlled substance. Now, if you have a right to it, you give us a call, contact us, and let us know what your right is. Why should you have this package? Now, PD knows he has no legitimate expectation toward that package. And what most people do when they get a seizure notice is file it away, some of them in the circular file, but bottom line is they don't respond. They figure it can't go right, because now it's bad enough that I tracked the package, but now to try to call and talk my way into them sending me the package, I'm probably going to talk my way into getting myself arrested. Right. So the seizure notice is the easiest to deal with. But let's recognize that PD's now sort of out of the foxhole, right? So PD's IP has been, could be tracked to tracking that package. PD's address now is known as an address where steroids were being delivered. So there might be some databases that PD's name and or other information is now logged. Theoretically, they could even get a mail cover to watch for more packages. So now they're sort of flagging PD's address. So if the following week another package comes or 3 more packages come, maybe now they're going to take a more aggressive approach to PD. But that's sort of the first scenario.
Okay.
The second scenario is the knock and talk. So what's a knock and talk? Well, if the feds think this is a little more than just a seizure notice that's required, but they don't want to go through all the trouble of trying to put the package in PD's hands, which we'll get to in a minute.
Yeah.
They show up at PD's door.
Oh, God.
They knock on PD's door. It might be 2 guys in suits who've got some badges. And when PD answers the door, they've knocked and they want to talk. PD, we got to tell you, we found a package in the mail. It's addressed to you, and it's got steroids in it. Did you order this package? Do you order packages? Have you ever ordered any packages from China? Do you take steroids, PD? Talk to us. Listen, we don't really want to be doing this on your doorstep, attracting your neighbor's attention. Do you mind if we come in and we can sit down and talk a little bit about this? Listen, this is not a big deal. This isn't the biggest deal in the world. We just want to get some information. We're not after you. We can tell you we're not going to arrest you today, no matter what you tell us. But why don't you sit down and talk to us? So PD's given that opportunity to discuss packages, to discuss that package, other packages, steroid use, and obviously once they come into PD's house, they can't come in without a warrant. And that gets us back to the Fourth Amendment again, right? They need a warrant to come in, but there's an exception to that, and that is consent. If PD says, come on in, yeah, don't stand there. It's cold out, it's too sunny. It's reflecting poorly. Come inside and sit down. You want a cup of coffee? If PD invites them in, that consent throws out the requirement for a warrant. And obviously, once agents are inside a residence anything that they see in plain view
Yep.
becomes something that they're going to be looking around, right?
Yep.
They're going to see what's there. So, so if they see any contraband, if they see a weapon, if they see what looks like, even if they see stuff related to bodybuilding, that can certainly open up. Oh, I see you've got some bodybuilding trophies there. Wow. Let's talk about your contest prep habits.
Mhm.
So, so that's the Fourth Amendment says you don't. If they come in, they can't come in without a warrant. But if they come in based on your consent, that's on you, right? So that's sort of the knock and talk, and the controlled delivery is sort of the third possibility, and that's the most aggressive.
Hold on, Rick. Let's stop at the knock and talk. Obviously,
Yep.
I know you're going to get to this at some point, but people are on the edge of their seats now. Somebody comes to your door like that, FBI, FDA, postal inspectors, God knows who.
Right.
You don't have to. First of all, you don't even have to answer the door, correct?
Right. You certainly do not have to answer the door, although if you don't answer the door, they're probably going to come back, right? And if they're hell-bent on coming back, they can theoretically wait until, unless you're never coming out, sooner or later, you're going to leave the house. And if they're waiting there, they're like, listen, we were knocking an hour ago and you didn't answer. Now you're walking out your door and, why didn't you answer our knocking,
Now,
So
you're not obligated to say anything though, are you?
well, that's what we're going to get to, and I'll cover that, when I get to controlled deliveries. But because that you're right, Ron, that stuff, other than the consent issue, that you don't have to consent. If they don't have a warrant, you do not need to consent. But exactly what to do, we'll get to that in a minute, because it's really the same for the knock and talk and the controlled delivery. So I figured I know you're on the edge of,
I am.
people may be on the edge of their seats, right? But I figured let's save it to the end.
Okay.
And and then I think they'll get really what the takeaway is from all of this.
So
right?
the third scenario is the most frightening of all, the controlled delivery. Let's hear it.
You know what that is?
I do. That is personally, I don't know it personally, thank God, but I read your book, Legal Muscle, guys. If you haven't read Legal Muscle and you're someone who uses steroids, buys steroids, you got to get that book. Gosh, what a primer that was. So you'll correct me because I'm sure I'm not going to be totally accurate, but they will have a delivery. They've confiscated at some point. They've figured out you have steroids in a package, either through scanning it or whatever, and they're going to send someone to your door to have you sign for it. Who is
and they'll dress him up, right? They'll dress him up like he's your letter carrier or a private courier, whatever it is you're expecting.
Can they dress up like FedEx or UPS or anything, or no?
They can certainly have the FedEx person deliver it,
they would need the whole
under
truck.
surveillance. I don't know to what extent now private carriers are cooperating in that way, but certainly the FedEx guy can show up with the police surrounding it, drop it off. And so you're right. The point of it is to get that package into the hands of the designated target, the recipient. Right. And so one way or another, sometimes if worse comes to worse, they'll leave it on the doorstep, but they'll surveil it so that when PD Pump pops his head out the window, looks both ways, and then goes to the door and, takes that package into his grubby little meaty hands and brings it into his house, he is now in not just constructive possession, he's in actual possession of that package. And, we don't need to be lawyers to know the old saying, possession is 9/10 of the law, right? So he's actually in possession. And what will often happen is that the law enforcement authorities will get a warrant that is sort of like an anticipatory warrant. So it's based on the possession of the package. Once PD takes possession, that triggers the warrant's effectiveness for the law enforcement folks to enter the home. And so you will have, like you said, that's the scariest, right? Having two two guys in suits on your doorstep may not be fun, but having 15 or 20 agents, some of them in like riot gear,
Get down, get down, get down on the ground.
the whole, it's what you see on television, right?
Yeah.
And they'll separate the occupants. So, Petey's wife is in one room and Petey's in another, and they are essentially ransacking the home. They're going through everything. They're looking for not just controlled substances, but any computers, phones, anything that might have evidence on it. The warrant will spell out what they can take, but they can take any records, they can take cash, they can, if they find any firearms, those are going. So you've got sort of that movie scenario where everything is now going to be seized, analyzed, and presented ultimately, potentially, to a judge in court.
Wow.
So that's the worst case scenario. And if they have a warrant, PD can't stop them from coming in. If they've got a valid warrant, consent is not the issue. The warrant is the issue.
Wow.
So now we get to, I think, what we've been waiting for, right? So now PD's sitting there, and whether PD's sitting there because he's invited them in for a knock and talk, or that they're on the doorstep, or they're searching the place, he's sitting in a chair, maybe he's handcuffed sitting in the chair, and now they start asking PD some questions, right? Because they want to know what's going on. And they'll say to PD, listen, you can help yourself out here. Tell us what's going on. Did you order these steroids? Are there steroids? Save us some time. Where do you have the steroids? Do you have some cash? Where's the cash? Do you sell steroids? Do you have a firearm here? All the sorts of questions that law enforcement will ask in order to strengthen a case against the person, right? So most people will do one of two things: either admit or deny.
Yeah.
Those are sort of the fork in the road arrives, and you choose one or the other. So let's talk about the admitting issue. And this is true even in the knock and talk. Knock, knock, PD, we got this package. What's up with this package? Did you order this? Right. Well, yeah, I ordered it. Okay. Do you use steroid? Yes, I use steroids. How many other packages have you ordered? PD, we can just go on the Postal Service website. We can see how many packages you've gotten from China. In fact, we've already looked, and we know you've gotten 18 packages from China over the last 6 months. Why don't you talk to us and tell us what's going on? We don't know what's in the packages because we didn't seize those, but we do see 18 packages from China. Yeah. So PD now spills his guts. PD talks about everything that he's done. In some cases, I've seen situations where the evidence to arrest PD was not strong enough until PD opened his mouth. And once PD gave the critical information that resulted in a case against PD that never would have existed had he not made these statements. Wow. The strongest evidence against somebody very often is what came out of their own mouth. The defendant's own admissions. And it doesn't have to be in writing. It can be oral statements. Potentially, they're going to be written down ultimately by the agents, and the agents are going to testify. What happened when you went to the door? Well, PD told us that he had ordered 18 packages of steroids from China. So
I'm just going to interject for 1 second. We know the Miranda rights are read to somebody right before they're arrested. And the first line of that is, you have the right to remain silent. Anything you say can and will be used against you in a court of law. But in this situation, the knock and talk, they're not even talking about arrest. So but the evidence is still admissible in court that he told them all this, right?
That's a great question. And a lot of people think that everything that you say gets thrown out unless you are given your Miranda warnings. We see them on TV. You have the right to remain silent. Anything you say can be used against you. You have the right to enter. all of that stuff, right?
Yeah.
And many people think that that's the magical questions, that set of questions that needs to be asked before anything can be used against somebody.
Right.
Wrong, not true.
Hmm.
The only time that Miranda applies, in other words, and it's a case called Arizona and Miranda. Miranda was a guy in Arizona who had made a confession.
Right.
The only time that Miranda applies is if two elements are present. One is that you are being interrogated, you're being asked questions. So if you blurt something out, oh, are you here about the steroids? And it's not in response to the questions, that's admissible because that's no interrogation there. The other is custody. The person has to be in custody, and custody is defined as not being free to leave. So in a knock and talk where you're on the doorstep and they're saying, listen, we're not going to arrest you. We're just here to find out about this package. We're not even that interested in you. If you answer those questions, those are perfectly admissible answers. They would not have needed to give you any of those warnings because you're not in custody. You're free to leave. You could have just closed the door. You could have said, I'm not interested in talking to you, but you didn't. You talked to them. And once you do that, everything is admissible. So obviously, if you're handcuffed in a controlled delivery scenario, then you're not free to leave. Then they will give you the Miranda warnings before they ask you the questions, or they can't use what is said. But the other thing important for people to recognize about Miranda is the case doesn't get thrown out if they fail to give the Miranda warnings. They can't use your statements in the case. But if they find a ton of gear in your house, that's all coming in. That can be charged. The only thing that gets thrown out or suppressed is the statements that you made. That's it.
Got it.
So now, so you're asked these questions, whether it's you're sitting there and you've been given your Miranda warnings and you're in custody or you're not in custody. What can you do? And that's where we get back to the Constitution. And that's where the Fifth and the Sixth Amendments come in. Because the Fifth Amendment is the right to silence. It's the right not to say anything to incriminate yourself. So you do have a right under the Constitution not to answer questions. And the way our law is, no negative inference can be drawn if you say you're not going to answer questions, if you refuse to answer any questions. So you don't have to answer any questions.
Good.
The second is the Sixth Amendment, which basically says you have a right to an attorney before you answer these questions. And so you have every, it's within your bounds to say, I'd like an attorney before I answer these questions. You have a right not to say anything and the right to ask for an attorney. And before we said people go in one of two directions, either admit or deny. We've talked about how the admitting can sometimes get you pretty jammed up.
Yeah.
But so can the denying. The denying can get you jammed up. Why? Do you remember Martha Stewart?
Yeah.
Remember when she went to jail?
Yeah.
But it was like some sort of stock tip, improper stock thing that was sort of the involved aspect of the case. But she didn't go to jail because she did something illegal with stocks. She went to jail because she was not truthful when asked questions by law enforcement. And that's the problem with the denying, is that there's a law. It's in Title 18, it's section 1001. 1001.
Wow.
And what that is it is a crime to lie to federal agents when they're asking you questions that are material to an investigation. So when the feds ask Petey, when he's sitting there, did you order these steroids? I did not. Never. You don't use steroids? I never do. No, never have. Well, what about this package? What about this one? I've never seen that. I didn't order it. Well, did you track the package? I did not track the package.
Yeah.
Your IP address showed up as having tracked the package. That wasn't me. It was somebody else. Okay. Great that Petey thinks that this is all terrific because he's, I'm getting over on these guys. I'm denying everything.
Yeah.
The problem is Petey's committing a crime by denying these material facts associated with the investigation.
Wow.
So you're jamming yourself up if you're admitting, and you're jamming yourself up if you're denying. Don't admit, don't deny. So what do? What is something?
Keep your mouth shut.
Thank you. Yeah. Keep your mouth shut. Be respectful about it. Be polite about it. And whether it's at the door when the agents knock and say, you know, Petey, we want to talk to you about some packages. Or if it's Petey in the house and they're going through the house and they're looking at everything, why don't you tell us what's going on, Petey? Well, Petey has the absolute right to say, gentlemen or ladies and gentlemen, I appreciate you coming here, but I have nothing to say. I can't talk to you until I speak with my lawyer. Once I speak with him, I'll be more than happy to talk with you and tell you everything, but I can't talk with you until then. I need to speak with my lawyer. What does that do? Under the Sixth Amendment, the request to speak to a lawyer before questioning shuts down the questioning so that what they ask you after that is no longer admissible. And most law enforcement folks will stop questioning because they know that they're not going to be able to use anything that you say after that. And I've had many clients who admit, many clients who deny, and then they wind up coming to me and we find a way to make it work. But I've also had people tell me when the agents came to the door, I opened the door and I said, they asked me a question or two and I said, gentlemen, I'm sorry, give me your business cards, give me your information, give me your contact information. My lawyer will call you. I can't answer any questions. I need to speak with him, but he handles these sorts of things. That's why I pay him. And I got the greatest lawyer in the Rick Collins, guy's a genius. Do you know him? But kidding aside, I've had people just ask for cards and I've had agents give them their card and say, have your lawyer calls. And then at least you've got a buffer. Then you've got a lawyer who can find out what's going on. What the lawyer says is not going to be held against you. Your lawyer's smart enough not to make statements on your behalf. And so then you and your lawyer can figure out what the best course is. And at some point it may make sense to speak to the agents, but it would be in a controlled environment where the sorts of things that you say can't be used against you potentially. Or it may make sense, you know what? Do your investigation and we'll see where this all goes. And I have had situations where a client has called me, I've called law enforcement, there was no admitting, no denying, no statements made, and law enforcement really couldn't make a case without that. And so the case just went away. The client was polite. I was very nice to law enforcement and said, listen, my client's not going to speak at this time, but certainly let me know if there's anything further that we can do, if you have more information, or certainly if there's any charge, we will surrender in a gentleman's very polite way. And the case just went away. So the smartest thing that people do is to not admit, not deny, to shut up, shut your mouth, other than politely asking for contact information and saying, my lawyer will call you. Then call me right away and we'll deal with it.
Yeah, so it's very safe to say that nothing good can result from you speaking, answering questions. Nothing, because there will always, it's their job. They're building a case against you. They want to see you prosecuted to the fullest extent of the law. They're not, they can pretend all day to be a nice guy, good cop. We're just trying to help you out, trying to blah, blah, blah. But, they're not your friend. They're not really trying to help you out. They're trying to help themselves out. So just shut up, guys. Just shut up.
Yeah. I mean, I have friends in law enforcement. They have a job to do, right? So they're doing what they need to do. Their job isn't, my job is to help you. When I get hired, my sole responsibility is to think about the welfare and well-being of that client, to make sure that client gets the best possible outcome and result in any situation.
Yeah.
But their job is different. They're not necessarily, some guy who's like a low-level steroid dealer. Most of them are not, rabid to, I want this guy in jail forever, but they have a job to do. It's to investigate crime. And we've talked about before, whether steroids should be in the same general category or set of laws as cocaine and heroin and meth and, but it's a controlled substance, which gives DEA jurisdiction. And so they're going to enforce the laws. That's their obligation, is to enforce the laws. And if you're ordering steroids and you turn up on their radar screen, they're going to proceed methodically. And the typical course is to gather enough evidence against you to bring to a prosecutor, for that prosecutor to bring that to a judge and to shepherd you through the criminal justice system.
Now, Rick, you would have an excellent perspective to answer this question, because you're the go-to man that most people I know would want to call, obviously. Do you see interest from law enforcement in going after steroid buyers, steroid dealers in waves where there's peaks and valleys, like certain, maybe after a big news story or something? Or is it pretty steady? Because it seems like sometimes they're a lot more interested in steroids than others, but I don't know if that's just my perception.
No, I think you're right. I don't think anybody can quantify it. I don't think there's ever been a study on it, but I have that same sense, is that it comes in spurts. What precipitates a spurt of interest, I'm not sure. It may be media related. It may be, a sports scandal or something like that. One of the driving forces to the criminalization of steroids in the first place was the sports cheating component. Yeah. So that's certainly one aspect of it. Sometimes it'll depend on the interest of agents. So if you've got agents that are very, very interested in it and they decide to set up at some point a anti-steroid task force, and now they get a few arrests made, now those people, some of them will cooperate with the government and will give other names. And so then you'll see sort of a spurt, because there was information derived from a few arrests that then spread out and, incriminated a whole bunch of other people. So you'll see sort of a wave of spurts. We've also seen, they've actually had, if you remember, there was Gear Grinder and, Raw Deal. There are some operations that are federal operations specifically targeting steroids, ignoring all other drugs for that operation and going after, anabolics. So
our tax dollars at work.
Right.
I remember from your book, Legal Muscle, I just want to go back to the controlled delivery, because there was one thing you said: once it's inside your home, then if they have a warrant, they can come in. But I remember you said something about, at one point they used to put devices inside the packages so they would know if it was opened. So yes. I think it was a strategy. I don't know if it was a wise strategy of some steroid buyers would leave the package by their, on the mantle next to the door for a couple of days before they would open it, just to try to increase their chances of, I don't know, getting away with it, I guess you'd say. But right. Is that still something that's done, or as soon as it's in your house, it doesn't matter, they can come in and you can't deny it's yours.
Yeah, it depends what the warrant says, but typically, more often than not, just accepting the package is sufficient. Mm-hmm. But in some cases, they did put in, and probably still do, little devices which will show that the package was open. Certainly strengthens the case, right? Because it takes away any argument that, this was not my package. I don't even know what it is. I wouldn't even open it. Well, you did open it. Although I guess you could still say, well, I didn't know what was in it. I saw this package and I opened it. So the strength of the opening of the package, it adds something to it. Years ago, I used to see a lot of people would order and, receive the package and then quickly write return to sender and put it back out onto the doorstep as if they didn't want it. And, I've seen some of that as well. And I've also seen how law enforcement has responded, to those in the past. But very often the person has already tracked the package. And so there's other pieces of information, they can theoretically get, in some cases, unless the emails are encrypted, they can get from many of the servers emails that will show that the package was ordered, and so there's a lot of there's a paper trail in various ways very often. not always. And I know that a lot of my clients will try to limit the evidence, have a remail or have the package shipped to somebody who's got nothing in their house at all. And then that person then resends it, remails it by domestic mail, which is, like we talked about, more protected because it's a stronger Fourth Amendment protection in a domestic package.
Right.
So there are ways to kind of get around it, or attempt to get around it. But if law enforcement really is interested, they're going to keep trying. And the main thing that I would stress to everybody is it is your right to not answer questions. It is your right to ask for a lawyer. There's nothing wrong with that. That's protected by the Constitution. And that by doing that, you will limit the evidence against you, regardless of what evidence is already there. You're not adding more to it. And you're giving yourself the best possible strategy to move forward with an experienced person who's dealt with law enforcement before, who's seen this 1,000 times and knows the best course of action.
Yeah, I'm very glad you also stressed the importance of not lying. Just be quiet, because I didn't even realize lying like that, not that I was about to plan to do it at any point, but that could add charges. And even if all the other charges dropped, I bet there are people that have gone to jail based on just lying to officers in a situation like that.
Martha Stewart, for one, right? Yeah.
I mean, geez, if they can put Martha Stewart in jail, guys, they can put you in jail too. Trust me. She was America's sweetheart. So, wow. A very interesting conversation, and so appropriate because I just hazard to guess 95% of everyone I know that uses steroids gets them through the mail, domestically or internationally, some way or another. And Instagram, you see it, it's everywhere now. So yeah, know your rights, people, and go to that steroidlaw.com, get the phone number, and program that into your phone under Rick Collins, Esquire. Hopefully you'll never, ever have to call Rick. But if you do, there's nobody in the world you would want handling your case more than this man right here.
Thank you, Ron.
He's the man. Yeah, cool.
Thanks, man.
Well, that's been an excellent episode number 3 of Legal Muscle with Rick Collins, Esquire.
Regal's okay.
Yeah, you have a regal bearing about you, sir. Check out steroidlaw.com for the firm and all that information. We appreciate you guys watching. Please subscribe to the channel, hit the notification bells, and we'll see you next time.